The question now is not if, but when will the health care bill finally reach the Supreme Court, because inevitably it will get there. Virginia Governor Bob McDonnell says that the legal decision is a victory for the Constitution, and he is calling on the Justice Department, as we've just pointed out, to fast-track the case, sending it directly to the U.S. Supreme Court. Governor, you just heard Stephanie Cutter. What is your response to her, which says she's basically saying that let the law take its due course, and it'll get to the Supreme Court when it does. There are other cases that disagree with what happened in Virginia, the Michigan case in particular.
Well, first, it's curious that she'd call it an individual responsibility provision. It's an individual mandate from the federal government on the citizens of Virginia and every other state. That's what the guts of Judge Hudson's ruling was yesterday, is that the Commerce Clause of the U.S. Constitution doesn't permit the federal government to mandate that you buy an insurance policy or any other good or service, and if you don't, to be fined, a penalty for it. The reason this needs to be fast-tracked, and I don't care if the governors are for or against the underlying health care policy, it is in the needs of certainty and predictability that we have finality soon in this case. I'd like all the cases to be fast-tracked. There's no need to go to an interim circuit court, Circuit Court of Appeals in this case. There's a provision, if the Justice Department and our state agrees, to have this go directly to the United States Supreme Court. Why waste another year and a half in litigation when there's millions and millions of dollars of expense that might be borne by the states in setting up all these exchanges and bureaucracy if they might be stricken by the Supreme Court? We just need an answer for the American people, and we need closure on this issue.
But as Stephanie Cutter in the White House have pointed out, only one court has struck down one of the key provisions, as you point out. Two others have upheld it. 12 have been dismissed. So yeah, the courts are all over the place. Why not let it follow its course? Are you trying to, quote, game the system?
No, that's really a ridiculous argument. That's another reason that ought to be decided. You've got different district courts with different rulings. You're going to have different appellate courts with different rulings. And everybody knows, Andrea, that this is going to be decided by the United States Supreme Court because they're the final arbiter of the Commerce Clause, the Tax and Spending Clause, and the entire United States Constitution. Why take 3 years and hundreds of millions of dollars of costs by the states setting up something that might be stricken by the United States Supreme Court? Let's cut a year or year and a half off the appellate process. Let's stop the litigation and go directly to the Supreme Court. It should make sense for every attorney general and every governor to have finality. Business, doctors, citizens need to know the answer. Is it or is it not constitutional? Are we going to have a mandate in health care exchanges or not?
Now, Governor, I wanted to bring to your attention a Washington Post op-ed today from the Cabinet Secretaries, Eric Holder, the Attorney General, and Kathleen Sebelius, writing, as these lawsuits continue, Americans should be clear about what the opponents, which of course includes you, of reform are asking the courts to do. Striking down the individual responsibility provision means slamming the door on millions of Americans who've been locked out of our health insurance markets and shifting more costs onto families who've acted responsibly. So you could argue that in the middle of this recession, still trying to get the recovery in gear, you've got a lot of people unemployed for many, many months. Why would you slam the door, arguably, according to this op-ed, slam the door on their opportunity to get some benefit from health reform?
That's mixing a policy argument in the middle of a legal case. I think there's broad agreement, Andrea, that a lot of people want to see expanded access. We want to see reduced costs. We want to see less litigation in the health care system. But this case is not about the policy. The case is about whether or not the Congress, the United States government, can make you and me buy a product of insurance or any other good or service, and if we don't, to fine us. That's the issue, is how they went about the process, and Judge Hudson has rightly ruled that you can't do that under the Commerce Clause. So no matter how these court cases come out around the country, don't waste 3 years in litigation. Let's go to the Supreme Court. They're going to make the final decision anyway. I think it's gaming it the other way by going through extensive litigation when everybody wants certainty, finality, and predictability. Business needs it. So let's get an answer, and let's get it over with one way or the other so we can go on and either implement it or redo it.
Governor McDonnell from Richmond, thank you very much. Good to see you, sir.